Some stories are known by seemingly every student who studies American history and political science. The oppressions of the British that drove us to draft the Declaration of Independence, the subsequent fighting of the Revolutionary War, the gathering of the founders at the Constitutional Convention, and the birth of a union that has stood the test of time and survived a civil war. However, there is another story that is less often told, but is of great significance. The following presentation is the story of the Bill of Rights. Where the rights came from, what they were meant to do, what they mean, and how they affect our lives today. As you will see, this is a story worth telling.
See you there. I was just reading about the history of the Bill of Rights. The Constitutional Convention has just concluded, and the proposed Constitution is being sent back to the states for discussion and hopefully ratification. There are some political figures who are having some reservations, though. Do you want me to read you what happens next? Our next stop will be in Virginia.
So it was that the Constitution was drafted, the Articles discarded. But with multiple objections was the Constitution bombarded. Unease and distress filled the hearts of a few founders. They took to the pen and to speech to make counters. The suggestions were many, there is much to recommend. Yet two prominent thinkers spoke to one common trend. The esteemed Thomas Jefferson and Robert Yates shared fright because the new Constitution lacked a Bill of Rights. Through Jeffersonian letters and Yatesian essays of dissension, another layer was added to the legacy of the convention. These thinkers made known their necessary condition. A Bill of Rights must be made as a constitutional addition.
I hate to be so negative. After all, the Constitution is a beautiful document. I mean, it's not as poetic or articulate as the Declaration of Independence, but James Madison did the best he could, given that America's most transcendent writer was in France at the time that the convention took place. Speaking of Madison, since he wrote the Constitution as it currently stands, I will write to him explaining my reservations. I'll draw up a quick outline right now and turn it into a more professional document later. Let's see. I should open with what I approve of. The three branches of government are a brilliant formulation, and the makeup of the House is sensible. However, a chief objection of mine is that there is no Bill of Rights included in this text. Without this aid, we stand to lose our rights to freedom of religion, freedom of the press, protection against standing armies, restrictions of monopolies, and trials by jury based on our domestic laws. All of these protections are vital for preserving liberty against a government that has pretty broad power. Some people think that a Bill of Rights is unnecessary because all powers not expressly granted to the government are reserved for the states. I have to say that I simply think that this is foolish. Liberty should not be entrusted to government deference. And now, for the ending, I can't help myself. I should stress again that without a Bill of Rights, trials by jury in civil cases may not be protected. And this would be catastrophic. Let me add also that a Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no government should refuse or rest on inference. As a general principle, I am not a friend to a very energetic government. It's always oppressive. And for this reason, I believe that a Bill of Rights is necessary to the Constitution.
Thank you again, cousin, for hosting me this weekend.
I'm glad you could join me, Peter. Representing Albany has kept you busy. I have not seen you for some time.
Indeed, indeed. Well, what is that you're reading? It seems to be upsetting you.
I cannot believe that these Federalist Papers are creating sympathy for the proposed Constitution. This document threatens to take away our individual liberties and create an oppressive national government. I've already written several papers talking about the dangers of a centralized government, but I don't think that the people have been convinced by my writings.
Robert, you need to write on something that will impact each American citizen on a personal level. Something that will make them seem that their rights are in danger.
What if I wrote about how the proposed Constitution does not have an explicit protection of individual liberties? Each of our state constitutions is founded upon a Declaration of Rights in some form. I find it astonishing that this grand security to the people is nowhere in the proposed Constitution.
Yeah, that would be a great subject for your next essay. That impacts each American citizen and every state at a personal level. Robert, you make this anti-federalist proud.
I must remind my readers that the powers, rights, and authority granted to the government by this Constitution are so extensive that they cover everything under human happiness. Life, liberty, and property are all under its control.
And the government could suspend habeas corpus, or pass bills of attainder, or take many other actions at seemingly any time. This Constitution gives the government a scope of implied powers that's troublingly vague, and we need a safeguard for our liberties.
I must also discuss how Article 6 of the proposed Constitution contains a supremacy clause that makes it ruler over all state constitutions. It does not have a Declaration of Rights like our state constitutions do, so it does not represent our states and it does not represent us.
Excellent. This has the makings of a great essay. Well, I'll leave you to your writing. I assume I'll be reading this under the pseudonym of Brutus?
Yes, indeed, Peter. Yes, indeed.
The Federalist Papers served as the Constitution's defense, which made the idea of adding a Bill of Rights tense. So Federalist 84 outlined Hamilton's qualms with the controversy concerning the Bill of Rights wrongs. Hamilton feared that to make such a change would be equivalent to putting the Constitution to shame, as the Bill of Rights allowed for power expansion, founded on faulty or flawed interpretation. To add to his case, Hamilton would dissent that a Bill of Rights statements would be irrelevant, and with these points being brought to the fight, Hamilton argued that the Constitution was its own Bill of Rights.
Alexandra, hello. You're just the person we wanted to see. We were just talking about you.
All good things, all good things.
Oh yes, presumptuously. What might the topic of discussion be?
Only your favorite thing ever. The idea of adding...
Well, this may be a sensitive topic. You see, we know that the Constitution is rightfully your pride and joy, as it should be. And there's lots of great potential there. But John and I were just talking, and we think that it could be benefited by adding a Bill of Rights.
Oh, no, here we go.
No, wait. Hear us out.
No, I've heard all the arguments before, and yet you don't seem to understand how risky an addition like this could be. A Bill of Rights is not only unnecessary in our proposed Constitution, but it would also be incredibly dangerous. The Bill of Rights would expand the powers not granted to the government, which only gives the government more overall power. Isn't that what we're all trying to avoid?
Well, of course.
Then think about it. Bills of Rights are, in their origins, stipulations between kings and their subjects, reservations of rights not surrendered to authority. Now, given these origins, a Bill of Rights would only grant the government more power and flexibility. It's a danger to the rights and liberties of the people, and it would give the government an increased agency to abuse their position. Is that a situation either of you want to risk facing?
No, this is a misunderstanding. A Bill of Rights would actually help to protect the rights of the people, not infringe on them. It's for the people.
That is practically blasphemous to the Constitution. Look, a Bill of Rights is simply a document of the superiors administering it. It's not for the people. The Constitution, on the other hand, is explicitly for the people. Look, it says right here, "We the people of the United States, to secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." As you can see, the Constitution is a better protector of individual rights. And, if you think about it, the Constitution is, to every useful purpose and for every rational sense, a Bill of Rights.
What protections are you referring to? Certainly they cannot be as important as the basic liberties that would be outlined in an explicit Bill of Rights.
On the contrary, the establishment of the writ of habeas corpus and the prohibitions of things like titles of nobility or ex post facto laws are arguably greater securities to liberty and republicanism than anything a silly Bill of Rights would contain.
Okay, Alexander, but hear us out. I mean, a Bill of Rights could help in saying what the government cannot do. A Bill of Rights could aid in the protection of people's rights by saying what the government cannot do in their power.
But that's ridiculous. Why declare that one shall not do which there is no ability to do in the first place? It's unnecessary. That's like saying, for example, the government shall not inhibit the press. Well, since there's no power to inhibit the press in the first place, why bother making an amendment about it? It's redundant, it's extra, and we don't need it. Look, that kind of Bill of Rights you're proposing would furnish a plausible pretense for the government to possess powers that are not theirs constitutionally.
You're thinking of this in such a negative light. Think of all the positives that could come out of it.
What would come out of something like this is a forfeiture of freedoms beyond what the Constitution outlines. The Constitution is our best protector of popular rights. The people give up nothing. And since they retain everything, they have no need of further reservations. You can tell your Bill of Rights that. However, gentlemen, I will thank you. You two have officially assisted me in developing my ideas for the 84th Federalist paper. I plan to fully demonstrate to people like you the dangers that would come from adding a Bill of Rights to our Constitution.
Well, that could have gone better.
You know how it gets sometimes. But a Bill of Rights being dangerous and unnecessary? It all sounds a bit ridiculous to me. I bet Alexander doesn't even know who else he's arguing against.
With the goal of countering those who argued in favor, Hamilton's words graced the May 1788 papers to show that the addition made dangerous loopholes that could infringe on the rights and liberty of the people. However, not everyone shared Hamilton's fear, as George Washington would show in the following year. In his first inaugural address, he expressed to Congress that adding a constitutional Bill of Rights may be best.
Within the Constitution, numerous powers and responsibilities have been explicitly granted to the Congress and the government at large. However, I also believe that it is up to the government's judgment to best apply these powers in a practical way and to what extent that they should be exercised. Therefore, I will not give any specific suggestions or recommendations on the exercise of such powers. Rather, I will support an addition of the Bill of Rights, especially if the government discerns it to be in the people's best interests and the public's greatest good.
Hamilton stood firm in his Bill of Rights opposition, but the anti-Federalist delegates demanded the admission. With the Union in the balance and both sides so adamant, all eyes were turned to the speech of James Madison. Madison wrote the Constitution in all of its glory, and wrote 29 Federalist papers to share its story. And in an address to Congress in 1789, he promised to add what would become the Bill of Rights. Though personally divided on the necessity of the change, Madison knew it was time to unite, not to estrange. He proposed amendments to be added to the Constitution's size, and the Constitution was ratified in the light of this compromise.
Gentlemen of America's First Congress, a matter of great urgency is upon us today. While many of us support the newly formed Constitution, there is still a great body of people who find it dissatisfying. However, if we alter the Constitution based on the single point of securing certain rights, I believe we will finally gain uniform support. I do believe that the Constitution is amendable, and I will not propose a single alteration which I do not wish to see take place. The abuse in government needs to be guarded against in a more secure manner than it is now. We have in this way something to gain, and if we proceed with caution, nothing to lose.
Nothing to lose? Hamilton has noted that the Constitution contains a number of such provisions already. What Madison's proposing here is quite unnecessary.
A great number of our fellow citizens oppose the Constitution because they find such safeguards absolutely necessary. Fortunately, we are able to satisfy the public's mind concerning their liberties. as well as avoid endangering and jeopardizing the Constitution. To achieve this, I propose the following set of amendments to be recommended by this Congress to the state legislatures. First, that there be prefixed to the Constitution a declaration that all power is originally vested in...
Wait. Aren't you just preambling the preamble?
That the people have an indubitable, unalienable...
And so Madison proposed before the House, even though Sherman and others had their doubts. As protections of rights were up in a scramble, Madison chose to include a pre-preamble. He expanded upon the rights given by John Locke, adding some others to strengthen the bloc. Some he proposed protected press and speech. Others guarded religion and the right to preach. Some dealt with trials, punishments, and warrants. Too bad the Congress lacked Gouverneur Morris. Adding some representatives could do no harm, as well as having a militia and bearing some arms. Religion could prevent one's military service. Oh, how Madison got those opposers nervous. Lastly, he argued to ensure checks and balances. These rights were for all, no matter their statuses.
Now, I must admit that I did not really take the idea of a Bill of Rights seriously. Yet, I also never viewed it as being entirely useless. I am aware that a great number of the most respectable friends of the government have thought such a provision not only unnecessary, but actually improper. Some have even gone as far as to consider it dangerous.
Hamilton.
I find their arguments to be inapplicable, however. And so, having done what I conceived was my duty in bringing before this House the subject of amendments, I think we should obtain the confidence of our fellow citizens in proportion as we fortify the rights of the people against the encroachment of government.
Let me add. In the words of Jefferson, a Bill of Rights are what the people are entitled to against every government on earth.
Eventually, the Bill of Rights was passed, yet Madison's ideas were not all cast. Congress chose 12 and seemed satisfied, of which only 10 were actually ratified.
And so, the Constitution was signed by the members of the Convention in 1787. Madison made his promise to include a Bill of Rights in 1789, and that promise was fulfilled in 1791. And that's how we got the Bill of Rights. Now, some people assume that the Bill of Rights was just automatically included in the Constitution as it was originally drafted. But it's really important to remember that there was so much more that actually went into it.
Wow, that's great. Thanks for sharing your story.
What? Wait, have you been here the whole time I was reading this?
Yep.
Oh. Cool.
I have a question though.
Sure, what's up?
What exactly does the Bill of Rights say, and how have they affected the lives of American citizens since their adoption into the Constitution?
You know, that's a great question. And actually, as a matter of fact, I have a second book right here that'll help in explaining that exact question.
Oh, perfect. Is this one also about the founders and their endless ability to argue with each other?
No, this one's actually a modern compilation of scholars today who are all experts on the amendments. By reading these summaries, we can gain a more thorough understanding about each part of the Bill of Rights.
Oh, great. Let's begin.
The First Amendment. Not many words,
but a huge impact.
The Establishment Clause is meant to balance out the Free Exercise Clause. The former prevents the government from forcing religion onto anybody. The latter protects each individual's right to practice what they believe.
Yeah, the tension between those two clauses can be pretty complicated. The Supreme Court has spent a lot of ink trying to find a consistent way of interpreting them.
The amendment also protects our freedom of speech and freedom of the press. The founders wanted to ensure that no oppressive government would take away our right to speak what we believe or spread the truth.
It's true. It is here also that we find the right to peaceably assemble. If a group of people feels as though they are being oppressed, they have the right to gather and make their voices heard.
Establishment exercise speech, press, and assembly. The First Amendment protects individual conscience in our country.
The Second Amendment proclaims that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Guess we better keep those Minutemen in shipshape.
Amen. That's why it's the best right out there. I love my guns.
Give me a break. Individual gun rights need revoked.
What just came out of your mouth?
I said they need revoked.
Why?
Actually,
There-
guys, when this amendment was written, the founding fathers might not have had individual gun rights in mind.
What? Huh?
That's right. The founding fathers may have written the Second Amendment with just the militia in mind. Basically, meaning that citizens had a right to hold weapons if they were gathering to form an army. In fact, it wasn't until the 2008 Supreme Court District of Columbia v. Heller that individual gun rights were even considered important. Ultimately, the court viewed the second as meaning pretty much the same today as it meant in early America, to have and carry weapons. So any individual can carry weapons, not just in a militia setting.
The Second Amendment allows for self-defense. With intentions unclear, the court ruled it made sense.
Third Amendment was a favor of those who had to deal with those neighborly red coats. Basically, soldiers cannot be made to dwell in your house except with your own permission or by the force of the law.
You're darn right. That right is a favorite. I work hard enough already taking care of these lazy bones over here. You think I want to clean up after more? Ha! I don't pay taxes for that.
That is exactly why this right exists, ma'am. Basically, soldiers were being made to stay in the colonists' homes without their permission, even in times of peace. The founders wanted to make sure that this wouldn't happen, so they enshrined this right in the Third Amendment, although it hasn't had much incorporation in the Supreme Court since then.
That is a shame. It really deserves more spotlight, especially for all us housewives and cleaners out here not wanting to clean up more messes.
Although it hasn't had its moment of selective incorporation in the court, it has been used to develop a doctrine of privacy.
Really?
Yeah, it has. It's been used in several cases to establish zones of privacy in medical rights, in rights of women in childbearing, and in rights of privacy in the home.
Would you look at that? This overlooked amendment really is important.
The Third Amendment protects your home and its privacy. Though not often applied, it still eases anxiety.
Many of us have heard the phrases unreasonable searches and seizures and probable cause. Well, these famous lines are found in the language of the Fourth Amendment.
The Fourth Amendment was enacted to prevent questionable arrests, seizures, and blanket searches enacted by the British during the Revolutionary War.
Today, in order to search one's house, a judge must issue a warrant, allowing police access to an individual's private home.
The significance behind the Fourth Amendment has become exponentially more important in the past decades. Following the heinous acts of 9/11, the court is now asked to interpret the Fourth Amendment according to technological surveillance, such as wiretapping and other forms of monitoring.
So, how important is
your privacy?
Does the language of the Fourth Amendment enforce a commitment to one's privacy? Or should law enforcement have leeway in catching alleged criminals and terrorists? The debate rages on.
The founders outlawed unreasonable searches and seizure so that your home and belongings are safe for your leisure.
What a mouthful. It seems like the Fifth Amendment contains a lot of important rights. I just wish I knew what they meant.
I get that from students all the time, but don't worry, it's pretty easy to understand. The Fifth Amendment basically lays out the rights of a legal procedure in court. It offers protections such as requirement of grand jury and trials, and offers security of double jeopardy.
Double jeopardy?
Yeah, double jeopardy basically prevents someone from getting tried for the same crime twice. For instance, let's say someone is tried and found innocent of committing manslaughter. They can't get tried again. Let's say someone is found guilty of manslaughter, the government can impose multiple punishments on them.
Wow, that would be terrible if the government could just keep giving you punishments for the same crime.
Oh, definitely. And another thing the Fifth Amendment safeguards is the protection of self-incrimination.
Is that why people often say the phrase, "I plead the Fifth"?
Precisely. When in court, a citizen doesn't have to answer any question that could potentially convict them. The Founding Fathers are so adamant about this self-defense that they wanted to protect them. And another thing is they wanted to ensure the protection of life, liberty, and property.
Wait, those sound familiar. Weren't they mentioned in the preamble?
That's right. The Founding Fathers restate these natural rights extra so that people understand that they are very important. And another point I want to make is the taking clause. Now, this basically means that when a government takes a private property from you, they have to give you compensation. So for example, let's say they take a field or a lakeside property, they must compensate you for performing that act.
Thanks so much, Professor. That's a lot easier than I originally thought. Who knew that the Fifth Amendment had so much more to offer than just pleading it?
The Fifth has property and the preamble in consideration, as well as juries and protection against self-incrimination.
You ever heard the idea of innocent before proven guilty? The Sixth Amendment is largely responsible for it.
If you were to describe America's criminal justice system in one sentence, you would most likely include a reference to the Sixth Amendment.
The Sixth Amendment ensures fairness and equality in the United States system of due process. Unlike Britain, America's founding fathers wanted criminal procedures to be public and transparent in order to prevent corruption in the judicial department.
Many Netflix and TV series like Law and Order or the O.J. Simpson documentary depict portions of the Sixth Amendment.
And whether it's the right to a jury, trial, lawyer, or witnesses, the Sixth Amendment covers it all.
Without the Sixth Amendment, the role of public defenders may have never been created. Those are the ones who represent those who cannot afford an attorney.
And furthermore, without the Sixth Amendment, people would have to wait in jail months just to get a trial.
The United States is rare. Criminals who are accused of crimes are given the benefit of the doubt. Thanks to the Sixth Amendment, deciding who is innocent, who is guilty is more likely to be done justly.
The Sixth Amendment outlines several criminal protections, which are a crucial part of the Constitution's complexion.
You may think that the Sixth and Seventh Amendments are around the same. However, there's a fundamental difference between the two. The Sixth Amendment grants individual rights to a trial by jury in a criminal court case or criminal offenses against the society.
Whereas the Seventh Amendment's civil law protections involve disputes or arguments, mainly between individuals or organizations.
In the court of criminal law, a unanimous decision is required by the jurors in order to determine if the person is innocent or guilty. However, in a civil court, only a majority of the jurors is required to reach a decision, making the right to trial by jury all the more important.
The Seventh Amendment relates mainly to federal courts and is not as widespread among the 50 states as the Sixth Amendment. Nonetheless, the Seventh Amendment is vital in securing the rights involved in monetary and other disputes.
Not just criminal cases, but civil trials too. The Bill of Rights ensures fair juries for me and for you.
You know, I hear what you're saying, and I get why you're upset. I really do. But the Eighth Amendment protects against all the ways that you want to avenge your loss.
No, you don't understand. He stole in plain daylight right in front of me. It's an outrage, and he deserves to be punished. What kind of person commits such an atrocity? He should be put in prison for at least 50 years with $1 million bail.
Well, no. You can't really do that. You see, the Eighth Amendment protects against excessive bail. And in this case, that's a little excessive.
All right, fine. Well, then he owes me a fine. $1,000.
Sorry, you can't do that either. You see, the Eighth Amendment also protects against excessive fines, and in this case, that's definitely excessive.
All right. Well, to make up for it then, I declare...
Hold it. Before you say anything outrageous, the Eighth Amendment protects against cruel and unusual punishment. The punishment has to fit the crime, and that's exactly what the Eighth Amendment protects. The Eighth Amendment is there so that criminals get humane treatment in every aspect of the law.
I mean, I get that, but...
Stop! The Eighth Amendment does not care that your roommate stole and ate your bagel.
I guess I see what you're saying. So the Eighth Amendment says that there are no excessive bails, fines, or cruel and unusual punishments?
That's exactly right, Stephen.
The Eighth says the penalty must fit the crime and outlaws outrageous punishment, bail, and fine.
So remember when Hamilton said that the Bill of Rights was dangerous because by enumerating some rights, we leave others totally unprotected?
Yeah, that was like the most important takeaway of Federalist 84.
Well, sometimes I wonder if Madison threw in the Ninth Amendment just for Hamilton. I mean, it completely answers his objective.
That's a great point. The founders understood they couldn't possibly write up an objection for every single government impression possible. So they used the Ninth Amendment as a safeguard against future offenses and the protection of all the natural rights that they didn't mention in the previous 8 amendments.
Yeah, so Hamilton lost this one. Come to think of it, this is one of the only times in America's infancy that George Washington disagreed with Hamilton about something. Washington was a big supporter of the Bill of Rights, as seen in his first inaugural address.
Another great point. Back then, it must have been nice to have Washington on your side.
For all of the individual rights not listed explicitly, the Ninth Amendment gives them constitutional validity.
This amendment must have been a favorite of the Democratic Republicans. It articulates the principle that Any powers not specifically delegated to the federal government by the Constitution are held in the hands of the states. That's federalism for you.
Yeah, although historically, I don't think the 10th Amendment has really lived up to the hype. You see, the government keeps expanding its powers, when it seems like at least, and you don't really see the 10th Amendment in too many Supreme Court cases.
Yeah, you're right about that. Especially after the ratification of the 14th Amendment. Presidents, legislators, and justices have been expanding the power of the government without too much backlash.
When Madison presented this to the convention, he had people like Patrick Henry in mind. But I don't think Patrick Henry would be too happy with how little it's been invoked recently. But it's still in the Constitution, and that means it's still part of the founders' legacy. Maybe it'll make a comeback in the years ahead.
The Constitution alone lists the powers on which the federal government operates. Any powers that you don't find in there must belong to the states.
And so there you have it. Not only was the Bill of Rights a pivotal part of our foundational history, but it still has major implications for all of our lives today.
Wow, I had no idea. It's easy to take the first 10 amendments for granted. I didn't even know they were in the Constitution to begin with.
Oh, sure. And I mean, honestly, they've been debated over from the moment they were first written, even through until today.
Incredible. So, what other books do you have?
Well, if you got time, I've heard that this story about the 16th Amendment is particularly interesting.